in long marriages and in the case of a homemaker, does the court in the UK award reasonable spousal maintenance until they die or remarry?
Um, yes. No.
Yes, no.
Yes. Next question. Okay. Okay. Hold on. I'm going to have to give a non-committal lawyer type answer to that question because it really depends on the fact of the case.
Yeah.
So when I first started, which is now over 14 years ago, I would see regularly something called joint lives order. And what that meant is that the husband was paying maintenance to the wife, not necessarily until the day that he dies, but until the day that he retires. So very, very lengthy maintenance orders. And I think the philosophy around that was if the wife has the children, and then she's taking a certain number of years out of the progression of her career to raise the family, she's never really ever going to be able to catch up with the husband. I think that was the original reasoning. Over the years in the case law, that has changed, and now the core principle is working out whether maintenance can be a transition to independence. That is the philosophy of what we're trying to do with maintenance cases nowadays. Now, it's still a little bit of a grey area. There are not really any precise answers here, but on the facts, the scenario that you mentioned to me, which is a long marriage, a dependent housewife, if she's in her 50s, for example, then I think it's right and fair if she hasn't worked for many years that she should receive maintenance for many years, maybe even until the husband retires. Because whatever she is able to do in terms of going back to work is going to be at a relatively low level, and it's not going to be for very long. So the court will order ongoing maintenance if it's necessary for the wife's needs to be met. That's one end of the scale. On the other end of the scale, you have a younger couple with no children, and maybe where the wife is still earning. Then you're not really looking at maintenance at all. There might only be a 1 year, 2 years of rehabilitative maintenance, getting her back on her feet. So it's a very wide spectrum. Of answers, and it can be difficult to necessarily pinpoint an answer, and it usually comes down to a negotiation within a range of reasonable outcomes. So yeah, sorry, that's a very lawyerly answer. I can't really pin down the exact.
I guess each case is going to be different from the next, and the permutations of how long the spouse has worked for, whether they've been a homemaker for the entire course of the marriage, or whether they're young or whether they're children. So I guess it's going to be different. But I think what's different in the UK is that spousal maintenance is not gender specific. It's not just for the wife. It goes both ways. Is that correct?
True. Yeah, that's correct. In fact, every principle of the law in England is always gender neutral.
Yeah.
Is that not the case in Singapore?
In Singapore, only husbands who are incapacitated can get maintenance. So if they're physically disabled or mentally unsound, then they can get spousal maintenance. But other than that, it's just the wives who can claim for maintenance, in addition to, of course, the children's maintenance. Yeah. So lastly, what have been some of the interesting cases that you've worked on?
There are always interesting cases, but I think maybe the area of law which might be of interest to your listeners is something called a Part 3 application. So it's named Part 3 after the relevant legislation. So it's Part 3 of the Matrimonial and Family Proceedings Act 1984. And what we can do under that piece of legislation is go to the English courts to seek financial relief after an overseas divorce. So from the perspective of my clients, we have an expat couple living abroad, and that can be anywhere. It can be Dubai, Singapore, Kenya, somewhere in the US.
Yeah.
If, let's say, the wife feels that she's got a terrible deal in the overseas jurisdiction, she has the opportunity to come back to the English courts to ask the court to look at this whole thing again. Okay. It was more. It's an easier prospect after a divorce somewhere like Dubai, for example, because the legal system in the UAE is very alien to English principles of division of assets. I think a Part 3 case after a Singaporean divorce is a different prospect altogether, mainly because the Singapore legal system is rooted in the English common law itself.
Yes.
Secondly, Singapore is considered to be an advanced country with an advanced profession. It's a very credible jurisdiction. But I am dealing with a Part 3 case in England following a Singaporean divorce. So we're in the middle of the process now. It hasn't concluded. The core issue in that case is how Singapore treats matrimonial versus non-matrimonial assets. So as I understand it, well, as I've seen actually, the Singapore courts draw a very firm line between non-matrimonial assets and matrimonial. And if an asset is classed as non-matrimonial, again, we'll use the wife as the example, the wife is going to struggle to make claims against those assets.
Yes.
That's different to England. Although we analyse whether certain assets are pre-acquired or they have been acquired by inheritance or by gift, that does make them non-matrimonial. That doesn't mean that they are ring-fenced from the settlements.
Yeah.
So if there are no other assets with which to meet the needs of, say, the wife and the children, then we can invade the non-matrimonial assets to effectively, to create the settlement that meets the needs, like for housing, for example.
Yes.
So the case that I'm dealing with, the major asset was a property which had been acquired by the husband before the marriage. They had lived in it for a short period of time as a family. Then they moved to Singapore, and then the divorce took place in Singapore. Now, under Singaporean law, the outcome was that the husband kept the entire assets, and the wife was left with not only nothing, but she was left with debt. So we are in the process of testing whether we can use the Part 3 jurisdiction to ask the English courts to look at this settlement again. And I think it's relevant to say that the property is in England, so it's within the jurisdiction of the English courts.
I see.
I'm quite surprised. I expected that I might be here for a year or two before the appropriate set of facts landed on my desk for me to even think about a Part 3 application. And it happened almost immediately on arrival.
Wow.
So we will get to a decision later on in the year. I'll report back to you and maybe we can talk about that.
I'd love to hear how it all pans out.